Medical examinations, they do take place. And when someone is involved in a claim involving an insurance company, they either got hurt, possibly in an automobile accident, or they're bringing a workers' compensation claim, the insurance company has a right to have the person who is injured examined by a doctor of their choice. It's called an independent medical examination. And that's what brings us to our case this week. It involves a man in Arizona. He suffered an injury at work, and he was badly injured. He was then sent to a doctor that was retained by the insurance company. The doctor looked at him and on behalf of the insurance company said, hey, you're not hurt and there's really no additional care that you need. Well, unfortunately the man's condition got worse and worse and worse. Part of his spinal cord died. He was in terrible medical condition. His family then sued, and they included suing the doctor who did the examination, contending that he committed malpractice because he didn't diagnose the condition the man was suffering from and he didn't suggest any kind of reasonable treatment. The doctor attempted to defend this by saying, wait a second, I wasn't hired by you. I was hired by the insurance company. I don't have an obligation to you. I have an obligation to the insurance company. The jury came away and said, no, we think that you had an obligation to him since you agreed to examine him, and we find you roughly 30% at fault for his injuries, for his ongoing medical condition. It went up on appeal. And on appeal, the appellate court in Arizona came away and they said, jury, you're right. In this instance, even though the doctor was hired by the insurance company, he agreed to examine this man, agreed to determine whether he had an ongoing problem, what the kind of injury was that he had, and whether he should have any further care. When he said he wasn't injured, when he said he didn't need any further care, he breached his obligation, an obligation to diagnose. The court was careful to say this doesn't open the floodgates to having suddenly a lot of suits being brought against independent medical examiners, but when an examiner agrees to examine someone who's involved in litigation and agrees to make a determination as to whether they're hurt, not hurt, and agrees to make a determination as to whether they should have ongoing care, well, that doctor then has an obligation to that person to provide good, correct, and appropriate medical care. Well, that's our story this week. Every week we come to you with another legal case, real cases involving real people, so you can find out how the law really works. I'm David Allen.